Welcome everyone to our February Q&A. Thank you all for coming, and thank you to everyone who submitted questions. We have a big list of questions, but if anyone is here and has their own, feel free to leave it in the chat, and we will I'll be monitoring the chat for any questions that come up. Harry, good to go?
I am good to go. Looking forward to it. These are always fun. Thanks for joining, everyone.
Great. Okay, so we'll start with some Fulton County questions. That is front of mind for a lot of people. There are two questions that kind of speak to the same thing. One is, can you explain the next special grand jury process in Georgia after DA Willis proceeds and outline her options? And the next is, will the new regular, in quotes, regular Georgia grand jury just read the other grand jury's report or need to call all prior witnesses and quote unquote start over?
Okay, and I'm interpreting the first one, Olivia, when it says the next special grand jury process, but I'm thinking that means the next grand jury process,
Yes.
not the next time there's a special grand. So what happens next? So first of all, everyone is going to be really at the edge of their chairs on come Wednesday. That's when a new grand jury is seated in Fulton County, a regular, normal grand jury. And there's some reason to think that Fani Willis will want to really get on top of it quickly. First is this a sort of technical point, but if there are any eventual speedy trial issues, it's measured is the speedy trial time from the end of the grand jury to after this one. So she will have maximum time if she brings it for an indictments that are brought early in the month. But I think just more generally, it's time for her to get on top of this process. And it would be passing strange if she didn't know what charges were going to bring by now. And, it seems like she really ought to. So starting Wednesday, the grand jury is there. Now, how will that process work? You might be thinking, oh, we'll need another 8 months, but we won't. So grand juries can receive what's called hearsay evidence, meaning they could have the report read into the record. They could just have some person, it may be an agent, sit in the witness chair and just describe to them everything that happened, so they can do it in summary form and without having to go through individual witnesses. Now, even in summary form, this is a sprawling case. We're reliably informed by our overly garrulous foreperson from the special grand jury that we're talking about 15, 16, 17 recommended indictments there if the DA asks for, and that will happen before a grand jury votes out. The DA will say, we ask you to return an indictment on these, fill in the blank. 15 people, a lot, or 16 or 17 or 18, a lot of people. There are, I think, unavoidably kind of two big cohorts. One are the Georgia state officials, but one are the whole Trump team. And again, thanks to Emily Coors, we know that a lot of these are from the Trump team, familiar names, as she puts it. And the specific charge, this is a real variable. They could go small from, I think the slightest would be solicitation to commit election fraud, to huge, a state RICO charge that would basically say the Trump organization from way back when is just all rotten and criminal, and it gives them certain advantages, but it's also sprawling. So how long the presentation will be, it could be as short, it seems to me, as a couple days, even for a new grand jury getting up to speed, and it could be as long as a week, even a little bit more of consecutive presentations. But from when it starts, and I don't see why it wouldn't start Wednesday or Thursday, that's, I think, when the clock is ticking. So we're looking at actual indictments of the former president of the United States, say within by the end of next week. One more variable. She doesn't have to do it all right away. she could come out of the box with one indictment or two or three, and especially it needn't be Trump immediately. But I see some decisions becoming public by the end of next week.
All right. We will stay tuned for that. Speaking of the foreperson, Rebecca Stowe, who I believe is here, wrote in a question saying, what fallout, if any, will there be from the 4 women in the Georgia grand jury? Can Trump or his lawyers get any traction from that?
Yeah. So Rebecca's short answer is I don't think so. It wasn't like it was anomalous for sure. It's not even clear that she departed from what the judge McBurney said, because McBurney drew the line at the actual deliberations. They've already been discharged. So that's her vis-a-vis McBurney. I don't see her getting into any hot water. But even if she did, look, so special grand jury gives a report to the DA, who presents it to a real grand jury, who does the actual charging. The argument would have to be, oh, and by the way, of course they will make it. You know what? They'll if the jurors, if anything happens in this trial that's at all ordinary, and you can bet that will be, they'll scream and jump up and down and say you have to dismiss the case. So of course they'll say it, but step back for a second. How could what Emily Kors say possibly give this impossible taint to the jury? It's not even the charges. All the information is going to be coming out damn soon. If it doesn't, it's because somebody hasn't been charged. So there's a lot of jumping up and down, but there's just no traction there, I think, as you put it, to actually say the whole case is unlawful. The one thing you can see is a couple feathers on top of the 10-pound weight that the jury selection process always going to complicate the jury process. Like extra question of, well, did you follow the the newspaper coverage of the foreperson, and did that, but what's even the next question? Did that influence you? At how could that influence them worse than the actual indictment, where a real grand jury is accusing someone of committing a crime? So I don't see anything happening, and I think the whole thing will be swamped pretty quickly by the earthquake that will be the indictments when they come down.
The next question is, what are your thoughts on Pence trying to use the speech or debate clause to get out of testifying, and Judge Ledig, a conservative, speaking out against him?
Yeah. So I go with Ludic here, but cards on the table. I'm much more candid in these Q&As than sometimes on TV. So maybe that's a good thing. I think this fake piety of Pence is really nauseating. So, but as Ludig writes in that op-ed, we have the profile and courage of Pence following the law on January 6th and saying he couldn't do it. I'm a little less, impressed with that. It's just, yeah, he followed the law, but this is really so. First, the claim is completely contrived and bogus. Here's what it is: the speech or debate clause protects legislators and members of the Senate from what the clause says is you can't be sort of hailed away for things that you say during debate. So you could interpret that as saying, and the court has, for legislative acts you're protected. That's certainly hot debate on the floor. Maybe it's some meetings or with constituents in your office, not clear, but the court hasn't had too much occasion to elaborate. But Pence, so everyone understand the claim here. He's saying, I, in the Constitution, am the president of the Senate, which he is, and therefore it would be a grave separation of power. I'm standing up for separation of powers. And it's that kind of the combination of how far-fetched the claim is with his piety of standing up for constitutional principle is what in conjunction kind of nauseates me. Because look, it's a total loser of a claim because there are times when he's president of the Senate. I think when he was presiding over the vote, that counts. And I think that should be a legislative act. But what Smith is seeking with the subpoena is the one-on-one conversations that only he had with Trump, where, he's in the Oval Office getting pulverized and pressured by Trump. The thought that he somehow, in his guise as president of the Senate in those moments and acting in a legislative way is ridiculous. And moreover, I think it's pretty clear why he's doing it. He wants to be president, and the only way to get here from there, and most people would call it, almost an impossible shot anyway. He's scared to alienate the Trump supporters, whoever it is, Trump or whoever from gets a Republican nomination, has to garner. And so he wants to be looking like he's fighting, and resisting at every step. And so he is, and he's filed, but this claim doesn't hold up. And the real Pence cherry on top to me is the notion that he's standing up for separation of powers. There is one galling aspect of it. As I mentioned, the court hasn't done a lot to interpret the speech or debate clause. Now, however they interpret it, this ain't a legislative act. He can't win. But it could take some time, unlike the executive privilege argument that Trump, by the way, is already making to stop Pence's testimony. That they have made quick work of that argument, and they should do it again in the courts in D.C. This one is, they're going to have to chew over. We found this out just today or last week with the D.C. Circuit oral argument in the Scott Perry case. It's just a little open-ended, and they don't want to get it wrong. They want to draw the right lines, and whatever lines they draw, Pence is over here. But drawing lines is going to take some time, and that may allow him to stall. I think, by the way, that's one reason why Ivanka Trump received a subpoena. She's a sort of insurance policy against Pence. She at least is in the room for some of the things that Pence is on the other side of. So lousy claim, and really unpersuasive. The standing up for constitutional principle threatens, in fact, to sully his, what Mike Luda called the profile in courage of his previous January 6th effort. This will look like, I'd say, a profile in cowardice. He's going to lose, but it might be successfully delaying the whole thing.
I have another question about an issue for the Jack Smith subpoenas. This is from Martha Brown, and she says, I have yet to hear a good discussion of the viability of the crime fraud exception to claims of executive privilege. Can you explain, and are there other privileges to which the exemption has been used?
Okay, so you haven't heard it because it isn't there. It's Martha. The crime fraud exception is very specific to attorney-client privilege, because what it says is, if these communications are in furtherance of a crime, the attorney-client privilege goes away and is vitiated. Now, in the executive privilege setting, the communications might be furthering a crime. That doesn't specifically vitiate the executive privilege, but it does the sort of same thing, which is it pierces it. So the doctrine from the Supreme Court from the Richard Nixon case actually is, if you need evidence of a crime, there's evidence of a crime there, and you can't get it otherwise, then the executive privilege yields. So let's imagine, for example, that you have it 10 different ways, including by piercing the executive privilege. Probably the executive privilege would stand because there's 10 different ways to get it, and it wouldn't matter. So it's very similar doctrine, but do you see the difference? The crime fraud exception makes the whole attorney-client privilege just go away, whereas criminal conduct that is caught up in communications that would otherwise be executive privilege yields, the privilege then yields for the need of a valid criminal law investigation for that evidence if that's the only way to get it. Similar bottom line, but you wouldn't call it the crime fraud exception. And didn't she also ask about one other kind of crime fraud? And was it the executive privilege? Was there one other kind of privilege?
She was just asking if there are other privileges to which the exemption has been used.
Okay, so crime fraud is something special for attorney-client privilege. The attorney-client, or it's actually furthering a crime, but there's other instances in which if what you're doing is against the law, it's the DOJ or authorities can get it, but you just don't put it in terms of the crime fraud exception. Hope that's a little legal, but I hope that's clear.
No, very helpful. One quick prediction question: will Roger Stone or Michael Flynn ever be charged with anything?
They sure ought to be, right? I mean, they're like wrestling villains, or the Joker and the Penguin or something.
Yeah.
So it's interesting. You're thinking about the entire circus of Trump world and your Jack Smith or others. Well, first of all, there's a very proximate stress point or danger point for Flynn, which is Fulton County. So he could figure in, but in general, it's pretty clear, I think, that these jokers function as a kind of conduit from Trump and the Oval Office types to the Proud Boys and Oath Keepers, etc. So that there are criminal conspiracies that you could try to frame there. And in fact, there may be some that have to go through them to build the whole case, depending on what they're going to charge. And if that happens, yes. Otherwise, though, as what kind of venal and vicious as they are, I think in the grand scheme of things, it's a very big scheme. They're probably too small fry for DOJ to be super worried about. So I think it's only if it's in the service of getting to Trump. That's vis-a-vis the DOJ, and they're not big figures in other states except Georgia. So Fulton County is where you can imagine their name surfacing. Bannon as well, but it really depends on how the crimes are charged, because they're kibitzers in a lot of ways, but they're not sort of front and center movers in the conspiracies.
If Trump wins in 2024 and is then found guilty for his alleged crimes, can he be removed from office? What is the recourse there, if any?
It would have to be impeachment. Okay. And he could be, but it would have to be impeachment. We know what that looks like.
Yeah, we do.
He could, by the way, he could get sentenced to 20 years and have to serve it after his term. Got it. He wouldn't serve while he's there, but removal is impeachment.
Yeah. This is kind of a different question, but is anyone investigating the $2 billion of Saudi money to Jared, and will anything come of that? I think this is something we've talked about a little bit on YouTube, but yeah.
It's very early. I mean, people, this is all stuff it's done after. My best guess is this first comes up, and it looks really lousy. But I think first you're going to see this surface in any kind of detail in the press. And if it's lurid enough, then maybe a file is open. But I wouldn't be betting on it happening independently. Otherwise.
Can average Americans bring a class action suit to remove legislators who planned, facilitated, or abetted Trump's coup attempt under the 14th Amendment?
Okay. Wow. Great question.
Yeah.
And it's so funny because people just don't know. So who asked it?
I don't have a name on this one, unfortunately.
All right. So just to recap for people who don't know it, who are listening, The 14th Amendment, Section 4 says if you swore an oath to the Constitution and you then aided or you then committed insurrection against the United States, you are not qualified to serve. It's the same thing as if you were 30 years old, you're not qualified to be the president. If you're foreign born, you're not qualified. There's only 3 or 4 qualifications. And the Supreme Court's made clear that nobody can add to them. So if that happens, you're out, says the Constitution, and there's got to be a way. And but this dates back from the Civil War, in the aftermath and Reconstruction, people saying of the old rebels, you if you swore an oath and then were in the Civil War for the South, you shouldn't be able to serve. And there's a whole interesting history there. But look, it's in the Constitution, and it has to be a constitutional fact. So let's assume that we had the birth certificate that said Trump was 33 years old. What would happen then? Because the real tricky and unknown variable here is what it takes to validly establish it. Now, if Trump's on the ballot to be a presidential elector in Arizona, I mean, there is precedent for people suing, just a normal person suing the election judge to say this candidate for school supervisor isn't qualified because of XYZ, and they're just being eliminated from the ballot. But we're talking about a national ballot. So there are 2 main candidates here. I mean, it does seem to me the class action suit won't fly, but the idea would be it wouldn't have to be a class action. I mean, I think also a single voter suit wouldn't fly. And the fact that it's a class wouldn't matter. It's just what happens. Somebody brings a lawsuit for a local court a local common pleas court says, Trump swore an oath, committed insurrection. Okay, you're disqualified. We got to know that somehow that wouldn't do to solve the whole thing. But so there are 2 options. The first is if he's found guilty of insurrection in a court of law by a jury, which finds the facts, etc. You would think that's kind of as solid as it can be. That's our mechanism for solving social disputes, having 12 women and men, good and true, decide. But you could imagine the Supreme Court saying, it's a political kind of determination, and a jury can't do it. What about a single judge that you bring? That's so. But the third possibility is Congress itself. So the last time this was used was about 100 years ago. Very interesting story. Guy from Wisconsin. It's World War I time. He's a socialist. He gets elected. He comes to Congress, and Congress says, "Oh, you can't serve." And he has to go back home. There's another election. He wins again. He comes to election. They say you can't serve under the 14th Amendment. So that would seem then eventually he's reelected and it all works out. But that would suggest that the constitutionally capable party or people to actuate this command in the 14th Amendment, Section 4 would be Congress. But that seems a little weird too. It's not normally their determination whether someone's committed insurrection. So it's a big puzzle. And for my mind, the best thing would be to do both. A trial and in Congress, because the worry is it goes to the Supreme Court, whatever it is, they say it got to be the other. So some combination has to be doable, and we just don't know. It's a real kind of strange law, constitutional sort of stalemate. So class action, maybe, but I don't think so. Single lawsuit, maybe. I think we're talking Congress or a court of law that and a jury, but you could see our counter arguments either way, and it's a bit of a constitutional brain teaser.
Yeah. Seriously. So turning to the Fox defamation suit, which there's also been quite a bit about in the recent week. This is from Terry Holmberg. Are there going to be any personal consequences for Hannity, Ingram, or Carlson for promoting what they knew to be a lie? Are they not almost as guilty as Trump for inciting insurrection for their coverage?
It's interesting. I just got finished talking about this on Deadline because what's basically been happening in this country for the last several years, somebody who people listen to tells a lie, and a certain cohort, like 35-40% of the country, a big part of them get all revved up, and then there's terrible damage done. People get beat up, or people get killed, or the Constitution gets trammeled, etc. So the lawsuit doesn't seek to hold them liable for January 6th stuff per se. It's enough if we just know that they were knowingly telling lies, and the evidence sure looks strong. And when you ask specifically about Hannity or individuals, it's funny because in the filing that just came out today, we saw for the first time deposition excerpts from Rupert Murdoch basically saying, yeah, we knew it was a lie, but trying to distance himself from the reporters that certainly include Carlson and arguably include Hannity and do include Jeanine Pirro and do include Lou Dobbs and there's one or two others saying now they knew and they lied about it, which won't be good for Fox. But I think he's trying to sort of preserve his the actual sort of corporate identity as not being responsible. But in any event, the big consequences will be Fox writing a check and a real reputational hit. I think Lou Dobbs, is maybe finished, it seems, and I'm no expert in the Fox, cosmology, but so I think it'll be the reputational hit. It's interesting to think about including Fox folks in any kind of criminal action. One of the things that also comes out in the Dominion filing is a really unsavory alliance between them. So Arizona's called, and Jared Kushner Fox says Biden's going to win Arizona, and Jared Kushner calls up Rupert Murdoch and says what's going on, and Trump is screaming in the background, and Fox is sharing stuff about the Biden campaign so there's this sense in which they're like this really are the like Pravda in Russia, just the sort of state media, and you can imagine that having criminal implications, but it won't, just in the sense that there's enough people to try to charge, and there would be real First Amendment issues. But it's a real world matter. They are responsible in part, but their punishment, as it were, will be a big check for Fox and a reputational hit for the reporters that you're talking about.
I have a quick follow-up on the same topic from Cynthia in the chat. She said, while you were talking, do you have any theories on why Fox hasn't settled yet, considering what I
don't think learned? Dominion. Well, first, it's pretty standard stuff. You have these behemoth suits, and you try to win it at the so-called motion to dismiss stage. And that's when you don't even have to get into discovery. They lost. Then you try to win it at the summary judgment stage, which is where they're at now, basically saying that even given all the facts, we have to win. That's the filing that came out today is that's the stage it's at. Then you're looking at now almost every defamation case since New York Times versus Sullivan was decided is dismissed at one of those two stages. So it's very, very rare to get here. But yeah, big corporation like Fox, once they're past motion to dismiss, and definitely once they're past summary judgment, that would be exactly the time they would cry uncle and try to settle. Dominion doesn't look too eager to settle. They're really, I think, cruising for a showdown at trial. And they really want Fox to pay, and to pay in the public eye. Now, there is one reason why maybe it should settle. We keep hearing it's a $1.6 billion suit. Dominion has Fox dead to rights, I think, on the liability. But the
Mhm.
whole company's worth like $750 million. So 1.6 billion starts to seem outsized. Maybe they think, but they still could get punitive damages, right? So maybe they'll think, wow, Fox, you know, Fox would, I think, tomorrow write $1 billion check if they didn't have to apologize. They would love to settle now, but I think Dominion's in the driver's seat, and unlike other cases where it's a big bad corporation like Fox and a little plaintiff, they're the really flexing their muscles, and it takes two parties to settle. So
Yeah.
that's the real reason.
So we have a question about the debt ceiling, which we also did a YouTube on recently. This is from David O'Connor. There are
Uh-huh.
numerous theories or ideas for how Biden can neutralize the debt ceiling issues, some of which were discussed in your conversation with Professor Dorff. Do we know if and who Biden or the White House staff has reached out to consult on these legal theories? I guess kind of a broader question too is just, do we
What is
know
it?
what they're
Yeah.
doing?
And
Yeah.
this is, the age of Trump. It's all these like imponderables and things that again are just constitutionally unclear because no one
Yeah.
if the brief reason, because no one's been, jerky or wicked or brazen enough to do them before. So the debt ceiling, we've been sort of assuming that Congress authorizes money, and and not the executive, and so you just sort of think that, like, well, okay, Congress stops permitting any money to be spent. I mean, it's pretty much done that and we reached a technical debt ceiling a couple months ago, but there are sort of tricks for extending it, so the real critical deadline won't be for a while. But there's still every indication that this House, unlike any other in history, is really ready to drive the car over the cliff. Which, just to take a step back, we're talking, catastrophe for a default for the United States, with true pain visited on so many citizens. We can go, but it's not just irresponsible, but kind of despicable that they're willing to hold hostage. This isn't about, I mean, they'll do anything to fight Biden, but they really want to harm the
Yeah.
country and the people. Okay, so the Dorf theory, it's very interesting. Tribe likes it as well, but basically, it's not to them. It's kind of pushing on the Constitution, and how do you get money? You can tax, you can borrow, and there's the third way I'm trying to think. But the the president can't tax. I mean, what are you going to do? He can't raise taxes. You can mint. There is this theory, you're able to mint coins. So why not mint a coin that's worth $3 billion? That's a sort of it seems a little bit too cute by half, but maybe. But you can borrow, and the idea would be, it's arguable. It feels like it's constitutionally suspect. But what if they just issue bonds, which is how the United States borrows. Now they would presumably be have to agree to go do higher interest. It's all, it'd all be very sort of funky, but there's
Yeah.
probably a market for them. So essentially what Dorf is saying is, given the what Congress has in mind, it would be constitutional enough. Oh, let me take a step back and do this huge fact that, if it keeps coming up in the debate, but it's really important. This is not what the House is threatening to do, is not print more money. That sounds good. We're gonna draw the line now, and we're not gonna go further into debt. But no, they're talking about welshing on obligations the U.S. already has undertaken. They're
Yeah.
talking on making us deadbeats. So it's just really important to understand that it's, maybe the executive couldn't do anything to say you have to keep, you have to fund something new or do this for highways. But it's another thing for the legislature to actually say the United States full faith and credit is behind a promise it already made to fund Social Security, to buy these things, et cetera. But we're pulling the rug out from under. And if it's the president who's pairing that, disastrous and likely illegal maneuver, then says Dorf and Tribe and very big pointy headed brainiacs, uh then maybe you can't do it. All right, so now
Yeah.
back to the simple question: what brainiacs is the White House counsel in touch with? I think those brainiacs keep quiet, but it's pretty clear that one of them is in fact Larry Tribe. He was in
Mm,
touch with the Congress during impeachment. I think you reached out to him. Ron Klain, who recently departed chief of staff, is a former student of Larry Tribe's, and Tribe is happy to play that role. So he's one, but I can think of others. I don't think Dorf is one, interestingly, but Dorf and Tribe have sort of kind of formed this together, and I think Tribe can be giving advice. But imagine the day happens and Biden decides to go way ultra vires here and do, knowing it's going to
yeah.
go to the Supreme Court. You'll certainly want to stitch it up legally as best you can, but it'll be a very dodgy proposition.
So one question about Trump's many lawsuits. This is from Karen Terry. With so many frivolous lawsuits, with all of the frivolous lawsuits Trump files, isn't there a law somewhere that a judge can order future lawsuits by an individual be reviewed by the court before being allowed to file a new one? Basically, are there any restrictions on Trump's ability to continue to file all these lawsuits?
There are. I mean, it exists. So in the Supreme Court, there are people, you can file things for free if you're a prisoner. And there have been prisoners who, every couple weeks lob in a new one of,
Right.
the kingdom of Mars unlawfully imprisoned me. And the court reaches a point where, it's a kind of a deep conflict with the notion of the courts as the one person lobby. The question is really precisely stated for that reason. They don't completely foreclose, because there's always the Gideon versus Wainwright, which is a really important suit that prisoner brought that could be out there, and so would really be unconstitutional, I think, to bar them completely. But to have
Yeah.
that kind of gate, yeah, it could be done. Now, a court saying, as to Donald Trump, the former president of the United States, you're going to have to go through that procedure. That would be,
Yeah.
like taking down his pants and spanking him in public. That would be an amazing day. I just can't see it.
All right. Just going to return to the many Trump investigations. We have a few more that have come in. This is from John McKenna.
Hey, John.
So can the Georgia DA charge Trump without the need of a grand jury? It's done all the time in California. So kind of why is she using a grand jury?
The short answer is no, or they won't here. Yeah, there are a couple ways to charge. One way to charge: a DA or even a policeman in some place can bring a criminal complaint.
Mhm.
Say, and just on my say so, I want you, court, to hold the defendant. But this is basically what habeas corpus is. You can't just have an executive have somebody be held without it being reviewed. So in those courts, there will quickly be a hearing where the court determines that it's an adequate charge to hold someone. And there are strategic reasons, even in the federal system, often for speed, that you can proceed by complaint, but then it has to be essentially ratified. Something like this, you would be, it would be seem very kind of corner cutting, or worse, to just do it on the say so of an executive branch officer.
Got it. That was one that I was curious about too. So great.
You mean the other ones you've been indifferent about all this time, Olivia?
Prior to the call beginning.
All right.
After having so many instances of mishandled documents and obstruction in the Mar-a-Lago case, what will it take for a judge to approve a search of Trump's other properties?
Sure makes sense, right? I mean, at this point, we almost have probable cause to believe there are others out there. But guess what? That doesn't do it. Just read the Fourth Amendment. In fact, what the heck? We don't normally do a cut. Do you? You probably can. Can you look it up quickly and read the Fourth Amendment for us?
Sure.
No warrants shall issue. That's the warrant clause. No, the second half of the Fourth Amendment. No warrants shall issue, but
upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things, and now it's saying ... to be seized.
Got it. So you see that? Particularly describing the place to be searched. So even if you could show by probability that statisticians would endorse that in one of these 6 places, there are going to be documents, ain't good enough under the Constitution. It has to be 1 Main Street, 2nd floor, and here's the reason. And it's fresh reason, by the way. It's, new information that's still valid why it's going to be found there. And short of that, even a very strong case that it's in one of these several places doesn't cut it under the Constitution. Thank you for that elucidation, Olivia.
All righty. Just a couple more before we are out of time. Do you think Merrick Garland would overrule if Special Counsel Jack Smith recommends charging Trump with anything?
No.
All right. And just the no. We're going with that.
If there's a follow-up, but I think no.
Okay, sounds good. And then we have a couple questions that kind of go together, so I'm going to read them both. Can you speak to any potential interplay between the testimony or witnesses in Fulton County and the DOJ investigations? For example, immunity deals or testimony from one affecting the other, et cetera, et cetera. And then there's another question. I'm curious, this is from Cynthia, who's here. I'm curious, what if the indictments overlap? Is it possible that several of these cases will come to fruition around the same time? So they're separate, but talking about the interplay between the 2 cases.
Yeah, that first one is a great question. So does everyone see how it could come? All right, I want to plead or I want to cooperate, and the federal government will make me a certain promise not to prosecute or give me a light sentence. But what about DA Fani Willis or DA Alvin Bragg? Now, the Constitution says, where this really comes up is you're giving information, including information about yourself. Sammy the Bull Gravano starts by saying, yeah, I did these, 15 execution style murders. And you're doing it, as part of that. You're giving information that inculpates yourself, or you're pleading guilty. You're saying I did it, and you kind of deal with the federal government that's going to be a few months or whatever the judge says. But now here comes Fani Willis to say, oh, you did it, right? I mean, look, you said so yourself. Now, the due process clause says that you can't be convicted by Fani Willis based on testimony that you gave under such a deal, which we would even call a kind of compulsion in the federal government. So legally, you can make that deal, and your lawyer will tell you, and so it's okay. She can't do anything. But that any defendant is gonna really want it stitched up better than that. Things can happen, things can go awry. And so even though that's the law, it seems to me that when it really comes, if push comes to shove and people are planning to cooperate, they are going to basically look to the United States and say, all right, look, I see, I trust you, but you've got to clear up this Georgia problem. You've got to clear up this Manhattan problem. In other words, notwithstanding the DOJ could then say, trust us, here's the case, the Constitution says it'll be okay. But I can well imagine defense attorneys saying, ain't enough. You DOJ go to Georgia, you DOJ go and stitch this whole up before, and that's a demand I'm making before I'll do it. So that'd be a really interesting situation, notwithstanding the law. And Cynthia's the second question is from Cynthia, is that right? That's another great question, because we're all sitting here with bated breath. Okay, here comes Fonnie Willis. Here comes Fonnie Willis, and it's going to happen soon. It's finally going to happen soon. It's finally going to, and it is going to happen soon. But guess what? As I've said before, I think she'll be first out of the starting gate, but not necessarily to the finish line. Take a step back here, guys. A local DA is about to indict the former president of the United States. If that's totally kosher, and maybe it is, but if it is, as soon as Biden's term is done, some cowboy in in Oklahoma can indict him. There's no legal specific prohibition on it, but it is a weighty prospect to greenlight this kind of criminal indictment. And that's just by way of saying that Trump will, for starters, there's all kinds of motions that any criminal defendant can do, and he's a particularly unprincipled or brazen criminal defendant. That's so he can stall things around for probably a year anyway. He'll try to move things to a different venue in Georgia, which will be more, Fulton County is purple anyway, and there's a lot of ruby red districts. All kinds of we'll hear about Emily Coors again and why the whole thing has to be dismissed, et cetera, et cetera. It figures to be, in any event, a year between and the indictment and the actual impaneling of a jury in an opening statement. But here there are extra, I don't know if we have lawyers or law students, but it's going to get intricate. He's going to try. This is kind of a little bit legally pointy headed, but you can possibly take the whole thing in state court and try to put it into federal court. And then you can bring all these claims that basically have to do with the, anomaly or possible threat to federal interests of having a former president tried. So when you talk about the interplay of these cases, you really want to consider, are you asking when they'll be brought or when they'll be finished? I think Bragg has a while to go, but he seems pretty hot on the trail. I think second is going to be Jack Smith. And we had thought to date that would be Mar-a-Lago, and maybe the January 6th case is not at all, but there's a lot of indication that he's really coming up quickly in the January 6th stuff. And remember, we're not talking only about Trump, right? It'll be a pretty seismic event if, say, Mark Meadows is charged, and he's someone who, if he's going to go to jail, might try to cooperate against Trump. So there are many different moving parts, and the movement is not simply out of the station, but back to the end. So just summarizing where I think things will, the things are likely as they now stand first to happen. I think Fulton County, Mar-a-Lago, January 6th Smith, Alvin Bragg. And by the way, we have a real trial coming up with the civil suit by the New York AG that has mondo consequences for Trump, and maybe that ought to be put in there too. That may be the first actual jury impaneled to sit in judgment on the former president of the United States. Long-winded answer, but a lot of details there. Okay.
We get the full lay of the land. That's perfect. So that is all we have time for tonight. You can see, Harry, there's some love for you in the chat. Thanks for doing
back
this.
Back at you, everyone. These are really fun. These are, I feel like, there's nothing to think about, but just like letting it fly. So if I can imagine saying things that this would be my last Q&A, but what the heck?
Yeah, exactly. And we'll be back next month for everyone. Thank you for joining. And in the meantime, stay tuned on YouTube on our weekly episodes. you'll see us continuing to talk about this stuff here. So,
Talk to you later, guys. Have a good month.
alrighty. Bye, everyone.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.